We're all set,
Okay,
David. Thank you.
okay, great. Um, Thanks for taking the time, everybody. As Beth Ann said, I'm David Kirk. Um, I'm a partner with the law firm of Troutman, Pepper, Hamilton, Sanders. Let me give you a very brief background about myself. I have a master's in city and regional planning, as well as a law degree. Between getting those two degrees, I worked at the Atlanta Regional Commission here in Atlanta for 12 years in their land use and transportation planning divisions. Worked on the regional transportation plan, transportation improvement program, airport system planning, transportation planning for the Olympics and Paralympics, and then left ARC for law school. Have been here at Troutman for 25 years. My practice focuses primarily on land use and zoning matters and annexation, couple of community improvement districts here in the Atlanta region. Also, early in my career, I worked on the Beltline redevelopment plan and helped write the legislation with a young city attorney named Stacey Abrams, who you may know or may have heard of, to establish the Beltline tax allocation district. My wife is also AICP. Some of you may know her. She's Lori Leland. She's the planning director for Avondale Estates. So we have a lot of interesting discussions over dinner about planning and zoning issues. But I appreciate you all taking the time. I am an attorney, so this is the fine print. This is just an educational session. It is not legal advice. If you want legal advice, put it in the chat, and we'll talk about you guys retaining our firm for that. But this is really an educational session aimed at helping you with preparing for the AICP exam. I'm going to turn off my video simply because, one, the rest of you all have your videos off too. And I'm also going to do that because my head's going to be turned toward a different screen, and don't want you to be looking at my ear the entire time. I like to start my presentation with this quote from Justice Brennan, who wrote that after all, policemen must know the Constitution, then why not a planner? And to that I say, absolutely, why not? Particularly planners that are studying for the AICP exam. So what are we going to try to do today? Well, obviously, we're going to help you prepare for and hopefully pass the AICP exam. I'm going to give you some thoughts on the process. I'm going to give you an overview of the sort of general principles that might be on the test. I have not seen the test. I don't know what is on the test. I took the test when I was at ARC, so that was at least 30 years ago, maybe longer. So it's not a substitute for your in-depth study on this or any other topic, and it's certainly not a survey of Georgia land use and zoning law. I give those sessions sometimes at GPA conferences and encourage you to attend one the next time we have one in person. I'm going to look at some of the areas of focus that I think you should know, and then identify some references and study resources that you might find helpful. So, thoughts on the study process? It's the old question: how do you eat an elephant? One bite at a time is the answer. And the same thing on studying for the AICP exam. Don't try to cram it all in the last few days before you take the test. Pace yourself. Spend a few hours. If you have a few hours every day, or a couple of hours every day, or most days, I would recommend you approach it that way, because looking at the AICP page on the APA website. There are a lot of areas that are covered in addition to law. Law is only a small part of it, and to master those sufficiently to pass the exam, you really do need to devote the time to doing that. So I'm going to talk very briefly about some general terminology and practices of the legal profession, talk about some foundational legal principles, some of the statutory basis for planning, the context of the plan, and then ways to implement the plan. So, general legal terminology. You should be familiar with this. I'm not going to explain every one of these in detail, but certainly knowing the difference between the plaintiff, who is the person who's bringing the case, and the defendant. Typically in land use, the plaintiff is a aggrieved property owner or potentially an aggrieved neighbor. In a zoning decision, the defendant is often the government regulatory body. An appealable decision is something that has reached sort of its administrative conclusion and then can be appealed to the court system. An appellant, an appellee. An appellant is the party who is bringing the appeal. The appellee would be obviously the person who was defending the decision below, saying that the decision was correct. You need to know the difference between a constitution, a statute, and an ordinance. And in terms of the case law, you will see in some of the materials that AICP has on its website, they will talk about the facts of the case, which gives you the factual background of the issue, and then the holding is the decision that the court, made in connection with the case. And we'll be talking primarily about the holdings of cases today. De novo proceeding is an appeal that allows the court to look at more than just what was the record below. Typically, a zoning case is a de novo proceeding, whereas something that's a quasi-judicial decision below, like the grant of a variance, is a review on the record, where the court will look only at the record that was presented to the Board of Zoning Appeals or whatever the body below was. So it doesn't bring in new facts. Jury and bench trial, there's a difference there. Jury trial obviously is what we're probably most familiar with. A bench trial is where the court itself, the judge or judges, are the finders of fact. They're the ones that try to sift through all the documentation, all the testimony, and determine what in fact is the truth. Here's some foundational legal principles and decisions that I think you should be familiar with. Obviously, on the left-hand side, we have the U.S. Constitution is the primary foundational legal principle you're likely to run into on the test. There are some cases, particularly having to do with fair housing, that relate to the state constitution. I'm going to touch on one of those. Then there are federal laws and regulations like the Religious Land Use and Institutionalized Persons Act. That's a federal law. There's state laws having to do with planning. Here in Georgia, we have a state law that governs the practice of zoning, the procedures that must be followed in a zoning decision. Other states have enabling legislation that prescribes the form for zoning ordinances and what must be in those. We don't have that here in Georgia. But again, this isn't a Georgia specific thing, but just know that state law and regulations do exist affecting land use and zoning. There are local ordinances, local zoning ordinances, local development ordinances, local ordinances that may have to do with specific uses in those jurisdictions that may not have zoning. Typically, those are things like telecommunication towers, landfills, other things like that. And then there's case law. And we're really going to focus on case law because I think that's likely to be the primary focus of the test is asking you, for instance, what's the holding in Euclid v. Ambler, and we're going to talk about that. But the case law are the decisions that have bubbled up through the appellate court system, usually all the way to the United States Supreme Court, and those form a foundation for future action by local governments and state governments with regard to land use and zoning issues. Some other principles that we're going to talk about, and I'm going to go into this in much more detail: due process, equal protection, takings, and then the First Amendment protections that you often run into when you're dealing with land use and zoning, particularly with regard to expression, religion, and speech. Okay, let's talk. Let's sort of drill down and talk more about due process. There are really two types of due process. This important constitutional concept that you should know. One is what's called procedural due process, and that, as you see from the slide, boiled down to its essence, means that if a decision is to be made regarding your property or someone else's property, someone's property, that person and often the community as a whole has to receive notice of that decision and an opportunity to be heard in what's called a fundamentally fair hearing by an impartial tribunal. So four elements of that: notice, opportunity to be heard, the hearing has to be fundamentally fair, and the decision-making body, the tribunal, has to be impartial. That's distinguished from what we call substantive due process. And that boiled down to its essence means that the decision that's being made by the government has to have a rational relationship to a legitimate governmental purpose. And we'll get into that a little bit more, but by rational relationship, I mean a conceivable, a reasonable connection to a legitimate governmental purpose. And legitimate governmental purpose includes things like you would find in the preamble to your zoning ordinance, protecting the health, safety, welfare, property values, et cetera, of the community. So procedural due process, that in my mind is it's probably the easier of the two concepts to grasp. That is why we put up signs or have the applicant put up signs announcing a zoning decision. I would not necessarily recommend the signs be this detailed, but it may be that in this particular jurisdiction, which I think was the city of Kingston, Rhode Island, there had to be, my guess is that the local zoning ordinance required all this information to be in there. That's why we have hearings. That's why when we have a hearing, we allow the applicant and supporters and any opponents to have equal opportunity to speak, equal time to speak, that sort of thing. So let's look at a couple of examples of procedural due process. And don't worry about these specific cases. It's really the concepts I'm wanting to get across to you. And I'm pretty sure most, if not all of these cases, there's a lot more detail about them in the AICP review materials, particularly those done by the Planning and Law Division, which has a pretty extensive list and description of the facts and the holding for these and many other cases. This Eubank versus City of Richmond, as you can see, it's an old case, but the concept is timeless. That there was an ordinance that was passed that basically said you can get a certain number of property owners and they can impose the setbacks on the entire community. And excuse me. And what this does is it brings into play that whole idea of impartiality, an impartial tribunal making a land use decision, because the concern here of the court was that one set of property owners could in fact have a bias or some wrongful motive with regard to their imposition of setbacks, and therefore the tribunal was not necessarily impartial. The next case, the Roberge case, again, the ordinance allowed for the placement of what they called the home for the aged and poor in areas only if those neighbors consented to it. Again, there's concerns about bias and wrongful motives, but there was also the concept of unlawful delegation of authority to those neighbors rather than the authority being vested in the decision-making body, the city council, in this case. It's certainly okay to have community input in zoning decisions, and I'm not familiar with any jurisdiction that does not allow it, either through the hearings or through a formal process like the City of Atlanta and others have with the neighborhood planning units. But the decision-making authority cannot be delegated to a group of citizens who are not authorized under law to have that decision authority. Here are a couple of others. The Lordship Park Association case. This is an interesting one because there was a draft plan that showed, this was I think really a subdivision case, if I'm not mistaken, where the subdivision was denied because it was a draft, this is waterfront property, and there was a draft plan that showed a road adjacent to the waterfront. It had not been formally adopted, but yet that's what the decision was based on. And here the court said, no, the draft plan, it doesn't have any legal standing until it's formally adopted. So you cannot base a decision on a draft plan, because the theory being that a draft plan, as you all know as planners, can change. It can change at the last minute in the final meeting where something is decided. So don't base decisions on draft plans. The Welton case, as I recall, this had to do with a Board of Appeals basically having free reign to make decisions with no standards. And again, in most of your, hopefully in all of your local government ordinances, There are standards for decision making, whether they be standards for the approval of a variance that often have to do with the unique characteristics of the property in terms of size, shape, or topography, or other unique circumstances. And then, as we have in Georgia and in other jurisdictions, for zoning decisions, there are standards in place as well. And here the statute basically said the Board of Appeals can make the decision, and they made a decision that effectively granted what's called a use variance to a party which was deemed to be unlawful. Okay, so that's procedural due process. And there's some overlap with substantive due process. And there are a couple of cases, I think at least one case that no, actually that's an equal protection case, but never mind. Substantive due process, again, a legitimate governmental purpose, the protection of the health, safety, welfare, morals, property values, quiet enjoyment of property, et cetera, et cetera. Again, just look at the preamble to your zoning ordinance and the intent of the zoning ordinance, and you'll see that that language is probably in there. And then a rational relationship to that legitimate governmental purpose has to be embodied in the decision. Let's give you a couple of examples of that. This is an interesting one, particularly because you got to look at the date here, where the ordinance required the consent of the homeowners for billboards in residential areas. Now, in 1917, a billboard was very different than billboards are now. Now, billboards are, 50 or 60 feet tall. They have, a big structure. They're elevated above ground level and can be seen from quite a distance. What I want you to envision here is essentially one of those sort of sandwich type, A-frame type boards that you sometimes see on sidewalks outside of restaurants advertising the food and drink specials for that day. But imagine one that's 10 or 12 feet tall and 10 or 15 feet wide. So it's essentially sort of like a hard structure pup tent. And here there was concern about trash and other things going on in that interior space that the courts found it did not violate due process by giving consent to the homeowners for that. An important one that I often look at is the next one, this Village of Belterre versus Barras. And here, the Village of Belterre had all its properties owned single-family residential. They expressly forbade the location of rooming houses and that sort of thing in the city. And then they said single family consisted of any number of people related by blood, marriage, or adoption, or no more than two people living together as a sort of as a family type unit that are doing their cooking and things like that together. This was challenged. I guess the important thing I should note is the Village of Belterre is right next to the State University of New York at Stony Brook. And so the village elders were concerned about noise and traffic and litter and frat parties and things like that going on in these single family neighborhoods. And so they defined family in the way that they did. I think if you go to your own jurisdiction's zoning ordinance, you will find a definition of family that has some numerical value in it. The city of Athens, Georgia, for instance, has the same number as Belterre did, 2. The city of Atlanta, I believe, is 6. Some jurisdictions have 4. But the question there was, does this ordinance bear a rational relationship to legitimate governmental purpose? And here the courts found that, in fact, it did, that the village of Belterre could have gone about addressing these other concerns in different ways, in terms of preventing, parking on lawns and having a noise ordinance and enforcing litter laws and those sorts of things. But they decided after consideration to make the decision to define family in this way, and as a means of discouraging large residential groups in their single-family dwellings. It doesn't have to be the best way, doesn't have to be the only way. It just has to be a reasonable and believable, what did I say? Whoops. A reasonable, conceivable, believable relationship, and the courts found that it did. I know I'm going through these very fast, but I want to get through this information, and then if there are questions, as Beth Ann said, put them in the chat, and I'll do my best to answer them at the end. Another critical constitutional concept that I think is important for you to know, whether for the AICP test or otherwise, is the concept of equal protection. And that stands for the proposition that you should treat those that are similarly situated, easy for me to say, the same, or if you're going to make distinctions, only make them on what are called legitimate grounds. You can't make a distinction based on a fundamental right or protected class, such as race or religion, that sort of thing, unless there's a compelling reason for different treatment. And when you see that word, compelling reason, that usually is a signal that the court is going to rule against you, because they typically do not find things compelling. And let's look again at some cases related to equal protection. The Eubank case, which I mentioned earlier about the setbacks, again, there's no compelling reason to treat one set of property owners on a street differently than another set of property owners. So that violated equal protection because they were all similarly situated. The next case is one that I hope you're familiar with, and if you're not, get familiar with it, because it's really sort of the case that allowed zoning to happen. Village of Euclid v. Ambler. In this case, there was the Village of Euclid had introduced a new concept that we actually call Euclidean zoning. Has nothing to do with Euclid, the Greek mathematician. It has to do with the village of Euclid, where you had different zones, residential zones, single-family residential, multifamily residential, industrial zones, commercial zones, that sort of thing. And Ambler Realty filed what we call a facial challenge, saying that the mere enactment of this ordinance violated due process, violated equal protection, was not a valid exercise of the police power. Police power being the ability of the government to regulate private actions to foster the public good. And the United States Supreme Court said that, in fact, the mere enactment of a general zoning ordinance that created these different districts, these different zoning districts, and says you can't have residential in an industrial zone, and you can't have commercial in a residential zone, is in fact a valid exercise of police power. It does not violate due process. It does not violate equal protection. So be sure when you go through the materials that I'm going to recommend at the end that you are familiar with this case. Okay, we're going to spend a fair amount of time on takings because that's really where a lot of the Supreme Court cases, both historically and recently, have addressed that. Takings arises out of the Fifth and 14th Amendments to the U.S. Constitution. The Fifth Amendment essentially says you cannot take private property. The government cannot take private property without just compensation. And the 14th Amendment extends that to the states. The 14th Amendment was actually a Reconstruction amendment that had a lot to do with the treatment of former slaves after the Civil War, but it's extended to this takings realm as well. So really one of the very first cases is this Pennsylvania coal case where the state required when coal was being mined that a certain amount of coal be left untouched in the mines to provide essentially support for the mine itself. And Pennsylvania Coal said, well, they're taking our property because it is coal that we could mine, get some value out of. If you're not muted, please mute your mic so that we can all hear. Thank you. And the question that the court really addressed was that regulations are taking of property without compensation if they go too far. And really the jurisprudence following this Pennsylvania coal case centered on the question of how far is too far. So there are a number of important cases. Again, I don't know how many of these, if any, will be related, will be addressed in the exam, but I want to take you through sort of a historical survey, I guess, of notable takings cases. The Penn Central case is an important one. Here, the developer wanted to put a modern office tower on top of Grand Central Station. The City of New York zoning ordinance did not allow that. They had a historic preservation plan. They had a transfer of development rights, transfer of air rights program in place such that the developer could actually, take that density that sat theoretically atop Grand Central Station and use it elsewhere. And so the court rejected the argument that this was a taking, and it looked at three important factors. It looked at the economic impact on the plaintiff. And again, here, there was some economic impact, but it was mitigated by the fact that the transfer of development rights, transfer of air rights was permitted. It looked at the extent the regulation interferes with, I put this in quotes because this is what the court said, distinct investment-backed expectations of the developer, and then the character of the government action. And here the character of the government action was to preserve a historically significant landmark, that being Grand Central Station. Another case, the First Evangelical Lutheran Church case. Here, this arose out of something similar to what we had just recently up in western North Carolina, where there was a terrible flood, and it wiped out a church camp, the Lutheran church camp. And in response to that, the County of Los Angeles put a temporary moratorium in place, saying, you cannot rebuild until we prepare a plan. And in fact, this was in fact a temporary prohibition on all development. The church alleged that this was a taking without compensation, that the County of Los Angeles had to pay them for the time that they could not develop their property. The court said, yes, you do have to pay damages when the regulation results in a taking of all use of the property, but the Supreme Court remanded it. In other words, they sent it back to the lower court to determine, based on the facts, whether a taking had occurred here. The lower court determined it had not, because there was, an end date to when the plan was going to be completed, and after that time, the church could rebuild the camp in accordance with that plan. But the important thing is it did say that if you take all use of the property, you do have to pay monetary damages. In this case, the court ultimately said there was not a complete taking for all time of the use of the property. It was only temporary. And so it sort of got a half a decision there. This probably is what I call the big three of takings cases. Nolan versus California Coastal Commission, Lucas versus South Carolina Coastal Council, and Dolan versus City of Tigard. In the Nolan case, Nolan wanted to build a house on the coast, and just like here in the Atlanta region, we have some level of review for things in the Chattahoochee corridor. The Coastal Commission is empowered to review developments along the California coast, and as a condition of approval, they required Mr. Nolan to essentially grant an easement through his property for coastal access by the general public. However, the plan that the Coastal Commission was working off of, the requirements that the Coastal Commission was working off of, had to do with access to views, not physical access to the beach. And therefore, the court ultimately said there was no essential nexus, no reasonable connection between the requirement that in the plan that there be some view maintained versus the requirement of the condition of approval that you allow the general public to walk through your property to get to the beach. I'm going to skip down to Dolan for a second. And this extended that concept to the essential nexus test of Nolan to the rule of rough proportionality. And here there was a small hardware store that wanted to expand just a little bit, and the city asked them for a long list of conditions that were the court deemed out of proportion to what they wanted to do, to the impact that the hardware store expansion would have. And I think that included building a bikeway or giving property for a bikeway, doing all sorts of other things that in fact was out of proportion. So you have Nolan saying that if you have a condition, it has to be connected to the actual impact and of the proposed development, and Dolan saying not only that, that condition has to be proportional. What you're, the exaction, what you're asking the property owner, the developer to do has to be proportional to whatever that impact is. Then let's move to Lucas, and this sort of extends the idea of that previous case, the First Evangelical Lutheran Church case. Mr. Lucas wanted to build. He bought two lots on the Isle of Palms down near Charleston. I think they were two of the few remaining undeveloped lots. And his reasonable investment-backed expectation was that he would be able to build a house on each of those lots, just like the houses extending down the beach in both directions. Well, soon after he bought those properties, the South Carolina Coastal Council imposed this imaginary line for shore protection that actually moved this imaginary line for shore protection from the front of his property to the back of his property, which meant he had, under that regulation, no ability, no right to, in fact, develop those properties. Therefore, the courts ultimately decided that the regulation took all of the economic use of the land from Mr. Lucas and required compensation. I think the compensation was roughly $1 million. And an interesting footnote to this is that basically the South Carolina Coastal Council paid him for the lots. They took title to the lots, and then they sold the lots to developers, advertising that they had beachfront property that they could build on. And that's how they recouped their $1 million. But these three takings cases are really three of the most important ones, I think, that you may want to study up on. The Tahoe case had to do with a moratorium that was imposed by the Tahoe Regional Planning Agency so that they could do a plan. And this is very similar to that First Evangelical Lutheran Church case, in that the court said that the mere enactment, this was what we call a facial challenge. Again, like Euclid was, it's a facial challenge. It wasn't what we call an as applied. It didn't have to do with a specific piece of property like Mr. Lucas's. It had to do with the fact that this moratorium was simply put in place. And the courts ultimately said that simply enacting the moratorium does not take property, particularly if that moratorium is imposed for the preparation of a comprehensive land use plan, and some other factors that played into that is that there was a time period for that moratorium to cease. So simply imposing a moratorium is not a taking. The Kuntz case, the fact pattern is a little bit interesting and a little bit complex, but basically, Mr. Kuntz wanted to develop property in Florida. He had a substantial amount of land, and he offered to dedicate about 11 acres of his land, most of which was in wetlands, but still offered to dedicate that in order to develop about 3.5 acres of land. The management district demanded that not only did he do that, but that he contribute about $150,000 to plug ditches and replace culverts that were up to 7 miles away from that property. And excuse me, and they refused to issue that permit because he refused to accept that condition. And this stands for the proposition there's no off-site exception to the takings clause, and also to the proposition that if you are asking if the government is demanding the applicant pay a certain amount of money in order to proceed with their development, the Nolan and Dolan test, the central nexus, the proportionality test applies here as well. As the photo indicates, this has to do with raisins. You'd think, what do raisins have to do with land use planning? Well, this has to do with physical takings. There are some physical takings cases that are outlined, but this was a recent one, relatively recent, about 10 years ago, where the Horns had they grew grapes, and the Department of Agriculture required them to give a certain amount of their crop to the Department of Agriculture, which presumably it would keep in some sort of secret location in order to keep the price of grapes high enough. And the Horns said, no, you're taking our property, and therefore you owe us some compensation. Ultimately, the Supreme Court agreed, and they said that the government has a categorical duty to pay just compensation when it takes your car, just as when it takes your home, and I guess just as when it takes your raisins as well. This case is interesting because it has to do with two lots or one lot, or the common ownership of lots, that sort of thing. And the Moore family had two substandard lots adjacent to Lake St. Croix in Wisconsin. On one of the lots, Lot F, they had a vacation cabin, and the state regulations prevented the separate use of those adjacent lots unless they had at least 1 acre. So both lots were under 1 acre. They wanted to move their cabin off of one lot and sell the other lot, but they were denied. They were denied variances, and they said, "Well, this was a taking," and they sought compensation. This is actually the parcel map, Lot E and Lot F. You can see where the cabin is, and they wanted to move the cabin to Lot E and sell off Lot F. I'm not sure why they wanted to do that, but they did. And here, the court was trying to decide whether those different lots should be considered individually or as a single parcel when they were deciding whether that should say prohibition against, not against, resulted in a taking. And the court determined that the combined parcel was the relevant unit for the takings analysis, because they looked at these factors below to determine that. Again, there's more detail should be more detail on this in the materials that AICP, particularly the Planning and Law Division, has. But I wanted to bring this to your attention because I had actually a picture of their cabin and a picture of their family, and I still have not figured out why those hobby horses are in the picture and why that young man is dressed like a jockey, but looks like quite the family. This is a new case, this Sheets case. This was actually just this year, and this had to do with impact fees, and it was decided just a few months ago. And I'm going to walk you through this. I'm not sure, this being a fairly new case may be too new to be on the exam, But for those of you who may decide to take the exam next year, it may well be on here. And so Mr. Sheets wanted to build a small or place a small prefabricated home on property that he owned. It was about an acre of property in El Dorado County, California. And the county said, well, in order to do that, you have to pay a traffic impact fee of over $23,000 in order to get your building permit. And that was a pretty hefty fee. And he filed suit saying he did pay the fee. He built his house, and he said the fee itself was an unlawful exaction under the Nolan and Dolan essential nexus and rough proportionality test. What distinguishes this from other regulatory takings cases, this fee was a legislatively set fee based on the general location, the general type of development, and it was not based on specific traffic impacts of his prefab single family home, which, as you all know, probably generated 6 to 8 trips a day. Again, if you have your mic on, if you could mute it, that would be great.
Hello.
This was in lower courts held here that Nolan Dolan only applied to permit conditions that are imposed administratively, in other words, imposed by the planning department or that sort of thing, that are on an ad hoc basis, and not to fees that are imposed through legislation. But in a rare unanimous decision, the U.S. Supreme Court held that the takings clause does not distinguish between legislative and administrative land use permit conditions. So this is important for impact fee programs across the country, here in Georgia as well, that they now have to satisfy both the essential nexus Nolan test and the rough proportionality test in Dolan. This may not be in the material that, well, I know this will not be in the summary of cases that the Planning and Law Division has on the website, but you can just Google Sheets versus El Dorado and you can find stuff. Particularly good piece of work that's been done on this was done by Arthur Chris Nelson, who used to be a professor at Georgia Tech. So if you Google Sheets, El Dorado, Chris Nelson, you can probably find that article pretty easily. Okay, enough about takings, unless someone puts a question about them in the chat. We're going to talk again. I'm not going to go into great detail about these, but important things for you all to know about cases having to do with the First Amendment. Freedom of speech extends to what's called freedom of expression. It's especially important for sign regulations and regulations of adult entertainment. The freedom of religion is often based more on the Religious Land Use and Institutionalized Persons Act as opposed to the First Amendment. And that act prohibits placing a substantial burden on religious exercise unless you have a compelling governmental interest. Typically, these cases that arise out of this act have to do with government regulation of houses of worship. You can regulate religious facilities and signs and adult entertainment, but you have to do so very carefully. And there are a couple of examples I'm going to give you. Mayor Detroit versus American Mini Theaters. You can imagine what they're showing in many theaters here. And this is the case that established the proposition that a local ordinance can place distance requirements between adult theaters and not violate equal protection or have that serve as a prior restraint on the rights of free expression. Typically, that local ordinance would cite studies about, if you have a concentration of these sorts of facilities, that they might give rise to an increase in crime or prostitution or other unsavory actions that the police power is meant to protect the community from. So typically that's sort of, distance requirements with regard to, if we're talking about, adult bookstores, the percentage of stock or percentage of revenue that they derive from adult content. I hope you're all familiar with the Reed versus Town of Gilbert sign case, which is about 10 years old. And here, the court determined that a sign regulation, you cannot regulate a sign based on content. You can't say, well, you can have signs that advertise bread but not advertise chicken, or advertise hamburgers but not chicken sandwiches. You can't regulate based on content. And if you have different rules based on the topic, the content, or the subject matter, they are in fact content-based regulations, and they're subject to what the courts call strict scrutiny. And again, strict scrutiny means it must be narrowly tailored to foster a compelling governmental interest. This is sort of a graphic of what how the town of Gilbert regulated signs. And as you can see, if I had an ideological sign that said, the end is near, then I could have that up for an unlimited period of time. If I had a sign up that said, vote for me, I could have it up for 4.5 months before the election and roughly 2 weeks after the election. If I had it for a homeowner association event or annual picnic, I could have it up for 30 days in advance. And then you see real estate sales. You had a much more limited duration. And then religious events, which is what this was all about, you could only have it up for 12 hours before that event, and it had to come down 1 hour after the event. And here the church involved was one of those storefront churches, so it moved from location to location each Sunday, and the pastor had to go around and put up signs saying, the church is this way, the church is that way, with every event, and he was cited for a sign code violation. And as you can see, a religious event was treated very differently from all the other types of content, and was found to, the ordinance was found to be in violation. This stands for the proposition that if you have to read a sign to regulate a sign, then you are regulating based on content, and that is prohibited. Okay, some other notable cases. I said at the outset that the state constitutions came into play with regard to housing. And this is in fact the case, the Mount Laurel 1 case. There have been other Mount Laurel cases following up on this, but under the New Jersey Constitution, not the federal Constitution, and you see in the citation to the case, it says New Jersey Superior Court. That's essentially their Supreme Court. That held that under that state constitution, a community has to provide its fair share of low and moderate income housing. And the township had a discriminatory pattern and practice of excluding multifamily dwellings on the presumption that those were primarily occupied by low and moderate income residents and was seen as discriminatory. In fact, the Mount Laurel case, my recollection is that the court essentially assigned itself the task of monitoring how well the township was doing in ultimately providing some level of multifamily housing. The Arlington Heights case, by contrast, is a federal case where the village denied a rezoning for a multifamily housing, but there was nothing in the record that indicated that this denial was based on racial discrimination, either intent or purpose. It did have a disproportionate impact, but you had to provide, in order to prove that equal protection violation under the federal Constitution, this was, I believe, in Virginia, you had to have evidence in the record that the denial was in fact based on a racially discriminatory intent or purpose. All right, we're moving right along. Eminent domain case. This is about 20 years old, but I think it still resonates today, particularly in a number of states that now require a supermajority of the local government to vote in favor of taking private property for not just for public use, but for some public benefit or public purpose. Here, the Suzette Kilo had this pretty pink little house in the city of New London. The city had a redevelopment plan. They wanted, I think, Pfizer to come in, and Pfizer said they were going to do a big campus in the city of New London. The city of New London took all this property. They did compensate. They exercised the power of eminent domain, which is the power of the government to take your property for public use. And over the years, the courts have expanded that term public use to mean also a public purpose. And here the public purpose was economic development, the redevelopment of a economically disadvantaged area. And ultimately they took Ms. Kilo's house. They were allowed to do that. But the eminent domain power is often used for large-scale redevelopment projects in jurisdictions, or certainly was back back a few decades ago. And another interesting footnote there: Pfizer never built their facility. They actually went to another jurisdiction not far away and built their facility. But unfortunately, Miss Kilo's house, cute little pink house, is not there anymore. Telecommunications law. I do a lot of telecommunications work, and I will not drive you to distraction with a lot of telecom cases, but this is one that bubbled up to the Supreme Court and actually involved the city of Roswell here in Georgia, where the city denied a T-Mobile application for a cell tower, but they did not provide. They did provide written notice. They said it's denied, but they didn't provide the reasons for the denial in a timely way, and under the Federal Telecommunications Act, a plaintiff only has 30 days from the date of the decision to file a complaint. And so this effectively made it very difficult for T-Mobile to say why they thought the tower application was unfairly and unlawfully denied. And this led to the Supreme Court basically saying, you've got to provide not only notice of the denial, you have to provide written reasons for the denial at essentially the same time. So curiously, they said it doesn't have to be in the same writing. But the lesson here is if your jurisdiction is going to deny a telecommunications tower application, they need to provide written notice of the denial and the reasons for that denial essentially contemporaneously with each other in order to meet the requirements of the law. Okay, everybody take a breath. I'm going to for just a second here. All right, some other things you might want to know about, and I promise we're getting close to the end here, is the statutory basis for planning and zoning. There's certainly some federal program legislation and rules having to do with transportation. I worked in, as I said at the outset, I worked for ARC for a number of years in transportation and land use, and there was typically every so often the federal government would come out with a new act or new regulations having to do with how local transportation decisions needed to be made, setting forth a process for that planning process. So federal programs and rules in transportation housing, CDBG program, that provides a basis for some of the planning that we do. Certainly, State Enabling Act and state constitutional provisions do as well. Here in Georgia, we have the Georgia Planning Act, which has to do more so with the coordination of planning, the preparation of comprehensive plans, the review of developments of regional impact, that sort of thing. In other jurisdictions, there are sometimes more detailed requirements with regard to not just the zoning, the procedures that you have to go through, but the actual substance of the code. South Carolina, I think, is certainly one. And then the city charter and the city code of ordinance is another place where you'll find basis for planning and zoning. I've mentioned this idea of the police power, and I think it's important for you to understand this. I will tell you that at least in a previous AICP exam, there was a question related to the police power. And again, this is the sovereign power of the state to regulate and control me in order to protect and promote the welfare of the rest of you. Things like speeding laws and pretty much any law that regulates my behavior to protect the community as a whole. That's the power of the state. It has to be delegated by the state to local governments. And again, the police power is really embodied in this phrase, protecting the health, safety, morals, convenience, general welfare, etc., of the jurisdiction. This is something that was on a test. I don't know if it still is, but the distinction between Dillon's rule and home rule. Georgia is a home rule state. Local governments have broad authority and powers related to matters of local concern. Dillon's rule is a little more restrictive. It says that local governments have only these three types of powers: those that are expressly granted, those that are necessarily implied or fairly implied or incident to the powers that are granted in item number 1, and those that are essential to the purpose of the local corporation, not simply convenient powers. And with Dillon's rule, if there's any sort of reasonable doubt as to whether a specific power has been granted, it has not. So home rule basically says you have broad authority, and that broad authority can be limited by other legislation, but if it's not addressed, you have that authority. Where in Dillon's rule, if you're not expressly granted that authority, or it's not clearly implied or essential, then you do not have that authority. Okay. The legal context of plans. Here in Georgia, we have plans are required as part of under the Georgia Planning Act. They can be authorized as well, but they can also be required. The plan does not control land use, and I say unless specifically referenced in the zoning ordinance. Here in the city of Atlanta, for instance, the zoning ordinance specifically says the city of Atlanta cannot zone property in a manner that is in conflict with the comprehensive development plan. That is not the case in most jurisdictions in Georgia, and I would surmise not the case in most jurisdictions nationally. However, there are certain ways to implement that plan that do have legal authority. Your zoning, your local zoning ordinance, your subdivision ordinance, your UDC or UDO. Many more local governments are going to that, which sort of combine the zoning and the subdivision and ordinance, as well as building design things as well. And then some jurisdictions have housing ordinances as well. Just one moment. Okay, well, I think we're pretty much done. That was quick, but we didn't have a ton of time. References and resources. I'm not sure that URL is the right one now. It was when I did this and I didn't check it, but I think if you just Googled AICP exam preparation, then that would take you to the AICP page that will give you all sorts of good information to help you prepare, at least for the legal section as well as other sections. Certainly look at Planning Magazine. That foundational land use law cases document is one that I think you will find on the AICP website. The Planning Advisory Service reports and policy guides, and then the Code of Ethics and Professional Conduct. You should be familiar with that as well, even though it's not strictly a legal issue. So that's it, folks. I'm happy to try to answer any questions. I don't know if any came up in the chat, but Beth Ann, I'm going to stop sharing.
All right.
Actually, I might stay sharing just in case I have to go back to something, though. Okay. It might take
That sounds good. Thank you so much for that presentation. I know that everybody found that very beneficial in preparation. I don't currently see any questions in the chat, but if you do have any questions, please feel free to unmute yourself at this time or drop the question in the chat, and David will certainly go over that with you. This is a great resource to have, so certainly utilize him while he is here. Um, we're seeing some thank yous come in on the chat. Um, David does have his contact information here. So if you do think of a question, certainly feel free to reach out to him. And I'm sure he would be gracious with his time to answer your questions.
I'll be happy to answer it at a deeply discounted rate.
Exactly. Well, I just want to take this time to thank you, David, again, for always giving of your time to help for the AICP review. And this will be posted onto the GPA website tomorrow morning. I just want to remind everyone of the last session tomorrow morning at 9:30, which is going to be the general overview session. So that one would be very important for you to attend. That Christina will be providing lots of updated information, and that session will also be recorded as well. So if nobody has any questions at this point, we will go on and log off for the afternoon.
All right. Thank you, everybody, for taking the time, and good luck.
Thanks so much,
You're all
David.
going to crush it. I know. All right. Take care, Beth Ann.
Thank you.
Bye now.
Bye-bye.